Swayam Prabha. Digital India. Educated India.
Welcome to all the learners. So, in the last class we have studied about the provisions related to the interest of consumers under the Electricity Act. We have also studied that what are the institutions which are being framed, which are being provided under the Electricity Act to protect the consumers. We also looked at those provisions where there has been a mandate to ensure the participation of public in decision making process. Now, in today's session we will look at that how the law is being further transformed to confer specific rights on consumers, because as I stressed in the last session that this act is very transformational, because it deals with public service, delivery of public service, and opens up the market so that private players should be involved in the delivery of such services. But at the same time, it is desirable that profiteering alone should not become a driving agenda for the market players, and thus categorically the law provided for necessary arrangements to advance the interest of the consumer. And in that regard, in the year 2020, the government has come up with the notification, come up with the rules to talk about the rights of consumer. The law has been framed under section 176 of the Act, which confers necessary power to the appropriate authority to frame the rules. Now, when you look at the objective of this rule, you would find the objective of the rule says it is about ensuring quality delivery of consumer services, and in order to guarantee that quality, what is needed, what is expected is that let us have a very clear understanding on what are the rights of consumer. And in that process, the idea is to lay down a bare minimal, that is why it says to minimum standards of quality. What is this to bare minimum standards of quality? This is about that what is something beyond which, if the licensee can manage, can always provide, but anything below than that is not permissive. And this kind of bare minimal approach you generally find with those set of rights which relates with socio-economic entitlements of individuals. In the realization of the socio-economic entitlements, generally what we have been observing that a practice of agreeing to provide bare minimum, agreed to provide that core is accepted, is getting a sort of acceptance worldwide. So, you can very well relate the same proposition even with the right to access electricity, because that is what we have discussed in first few sessions, that why the right to access electricity also satisfies the criteria of being one of the rights to lead meaningful life. But then if you talk about the practical implementation, if you consider that how it will be implemented at the ground level, you would agree with me that it is by laying down that bare minimum, so that anything below that should not be acceptable as the case of fulfillment of the guaranteed rights. And therefore, the rules suggest that there shall be new connection or modification of the existing connection to be done in a very transparent manner. It should be done in a time bound process, and then it should be also made simple, so that unnecessarily the consumer need not be harassed for getting the connection. And that is why, in order to minimize that harassment, or I would say in order to eliminate that harassment, the rule relies on the potential of technology. It says that online application is to be filled, and then once it is filled, it says that when it comes to metro cities, within 7 days connection must be provided. When it comes to other cities in municipal areas, 15 days, and rural areas it says about a month time. And why this different timeline? One can very well give the justification for the same, that it is about the distribution system prevalent in these kind of geographical locations, and it is easier, it is quicker to get the connection in the metros and the cities in municipal areas, and in rural areas perhaps the licensee require more time to lay down the infrastructure, to make the necessary arrangement. That is why this timeline differs. The rule also talks about metering, and what it says is that no connection shall be given without a meter. Now, apparently this appears to be a very obvious proposition, that why a consumer shall be allowed to consume electricity without having a meter at his premise. But then we know very well that this used to be a practice, particularly in village areas, semi-urban areas, or even in urban areas, in dwellings of different kinds, where people used to get the electricity without applying through a proper process. And that was not only causing financial loss to the distribution licensee, but also it was contributing to the overall efficiency of the distribution system. So, rule of 2020 makes it very clear that no meter, if there is a no meter, no connection, and that is what it says. No licenses shall supply electricity except through installation of a correct meter, and in that regard it is the electricity authority which has been advised, which has been suggested to formulate a regulation that what would be scientifically approved meter, the technical specifications, this is all the responsibility given to the electricity authority to come up with the regulation on that regard. On metering, what we find that the rule of 2020 makes a very progressive, this rule makes a very progressive approach, it adopts a very progressive approach. How? It mandates the installation of prepayment or smart meter. Now, how this becomes a very phenomenal one, because of the poor revenue collection by the licensee from a set of consumers. So, if you have a pre-meter installed, prepayment meter installed, then obviously it is about efficiency in collecting charges from the consumer. So, the rule says it shall be the case of prepayment or it shall be the case of a smart meter, but then if there is any exception, because we know very well that in our residences it is the postpaid meter which is connected, then there has to be an exception, and these are the cases of exceptions, and for that the approval is needed from the commission. So, installation of prepaid meters to me appears to be a structural change. Why structural change? Because it would drastically improve the billing system, and also if meticulously it is planned, then the whole issue of extending subsidy would be planned. If it is meticulously planned, then the transfer of subsidy, crediting of the subsidy amount be directly in the account of beneficiaries. That is what also the proposal in the pipeline. So, prepayment meter has this kind of advantages. One may look at it in a very positive way, that this would help in extending the necessary support to the targeted group on the one hand, and on the other hand it would also facilitate in bringing efficiency in the distribution segment, which as of now is a matter of concern. If there is a post payment meter system is there, and if the domestic consumer is not there in his residence, then what it says that only fixed charges are to be paid, and licensee shall not send any notice or provisional bill. What is to be sent is just the fixed charges which is there. A smart meter is another revolutionary change which has been introduced through this rule, because a smart meter would help in evaluating the consumption pattern of the consumer, and through that we can have a better demand side management. So, movement of people from one location to another location during vacation can help the distribution licensee to plan the procurement of electricity accordingly, and it can also help the consumer to plan on different set of activities. Same would also be the case with the bigger consumer. So, the consumer pattern can very well be defined, and what shall be the guidelines? Again, it is for the electricity authority to come up with, and already we have a regulation in this regard. So, a smart meter, no denial, will help in making the necessary planning at the consumer end, and it would also facilitate the distribution system to ensure value added services. Value added services in a way that quality supply of electricity when there is a peak demand, and therefore, this is a welcome step, and Government of India has already launched a program, a Smart Meter National Program, which aims to install a smart meter by replacing the postpaid meters, and this drive is steered by a government company, Energy Efficiency Services Limited, and already there has been a reasonable success in this drive. When I inform you about the benefit, there are also matter of concerns on the issue of smart meter, because a smart meter would help the miscreants in tracking the movement of the consumer. So, if a consumer is going for tourism in other location, and if there is no consumption happening at his place of residence, it would be easier for miscreants to make out that the residence is unattended. Other concern is the concern of surveillance, that through this process activities are being tracked of individuals. So, consumer privacy becomes an important issue with regard to the implementation of a smart meter. Now, shall we stop? Shall we abandon the drive of installation of a smart meter, or shall we look for a regime which shall balance the interest of the industry on the one hand and the consumer on the other hand? It is the latter which shall be preferred, and that is why it is needed to enact data privacy law at the earliest. Further, it also says, when you talk about the right and when you talk about the responsibility of the distribution licensee, that because electricity meter has to be provided by the licensee, or if the consumer intends to buy it from the market, then it has to be in accordance with the specification decided by the authority, and then in that case the charges for that meter would not be asked from the consumer. But if the consumer is not going and buying the electric meter on his own, then it is the licensee who has the responsibility to install it, and licensee does it after asking for a reasonable security. But then it says the licensee cannot refuse to supply in case of failure to pay the security. So, you can very well relate that how the right of consumer is been protected when you draw a sort of balancing between the financial interest of the distribution licensee in terms of keeping that security amount and the interest of the consumer to get the supply. When it comes to payment meter, obviously no payment of security. This is what is given under section 47(5). Now, section 47 subsection 5 also helps us in understanding that prepayment meter appears to be a thrust area under Electricity Act 2003, which has been attempted to get implemented through 2020 rules. Now, what shall be the specification of electric meter? When it shall be considered to be a kind of non-operational one? Section 50 empowers the Regulatory Commission to frame the code in this regard. Now, billing and payment is another important thing which 2020 rule deals with, where it says that there shall be a transparency in applying the tariff and also in billing the consumer. Further, it says that consumer shall have an option to pay online. That option of paying online would not only help the licensee to manage the man hour in an efficient manner, but also it would save lot of time for the consumer. And additionally, it is also been provided that if someone desires to make advance payment, that is also allowed. If the electric meter is not accessible to individuals in an extraordinary situation like pandemic and all, then what the consumer can do is that consumer can very well look at the, take the photograph of the meter indicating the reading and pass it on to the distribution licensee. In prepaid metering, responsibility lies with the distribution licensee to ask to issue a bill and give it to the consumer when the consumer is asking for the same. If the consumer raises a complaint on non-issuance of the bill, then the licensee has a responsibility to make the details available on the website. Now, when you look at all these measures appear to be small steps, but then these measures in a way adds to strengthening the power market, because it will help in building the trust and confidence in the consumer. And that is why we look at it that if licensee is not preparing the bill and giving it to the consumer, then in that case consumer will be entitled to get certain rebates. These provisions will make the consumer more responsive towards the use of electricity, and licensee would be more accountable. Responsibility of the distribution licensee to clearly spell out that what is the tariff for which category of consumers, so that there should not be any opaqueness in dealing with this. And then the rule also says that licensee shall supply 24/7 power to all. And then it further says, looking into the constraint, that lower hours of supply for some categories of consumer is possible, for example, agriculturalist. Further, in order to make the licensee accountable, in order to ensure the supply of reliable electricity, it is suggested that licensee must put a system in place which shall do the monitoring and restoring of outages in automated manner. Generally, when you look at it, it operates on this premise that there is a phone call which is made to the concerned department, then concerned department reaches back to you, says that okay, manpower has gone to the place. Now, all these processes, it has been suggested that if technology can help the consumer in demanding better services and facilitating the licensee to deliver better services. 2020 rule also acknowledges the status of consumer who is also a producer, and that is what the terminology which has been given as prosumer. So, the consumer who is a producer of who is generating electricity is given a sort of legal status recognition under 2020 rule. Now, what it says that even if a consumer becomes a producer, the consumer possesses all the rights which are available to the consumer, and then that consumer gets necessary right to set up the generating facility through renewables, including the rooftop, and that he is allowed to take up not only on his own, but he can also pull in service provider for the same. And in that, with regard to metering, a yardstick was laid down that where the load is up to 10 kilowatt, then let the net metering decide the billing part, and if it is above 10 kilowatt, then let there be a gross metering. Now, net metering, gross metering, what it is and how it operates and whether it is beneficial for the renewables or not is something let us look at. Net metering is about allowing the producer of renewable to supply the electricity to the licensee and accordingly get the adjustment in the billing. Gross metering is about consumer producing electricity, giving it to the licensee, but then the compensation what the consumer is getting is at a fixed feed-in tariff. And generally you would find that feed-in tariff is on a lesser side, is on a lower side than what is there for retail supply. So, gross metering does not create a very supportive ecosystem for the producer. And look at it, it says net metering for loads up to 10 kilowatt and it says for more than that it is the gross metering, that is what it says. Now, for rooftop, when it says so, it is not very difficult to visualize that in a way it creates a sort of disincentive for the large housing societies, for the industrial houses, commercial establishments to go for bigger installation of renewables and to produce more than 10 kilowatt of electricity, because in such a situation it will be the gross tariff which will be a gross metering which will be applicable, and gross metering means that you supply electricity, but then what you get as compensation is a differential pricing which generally is lower than the retail supply. So, you buy at a costlier rate, but then your own generated electricity you are selling it on a lesser rate. You are buying on a higher rate, you are selling it on a lesser rate. This is what is the scheme. Licensee is getting benefited in this process. Now, you may argue that if licensee is getting benefited in this process, it is good because licensees are struggling on financial front and this will help in improving the financial health of the licensees. Yeah, this could be one argument to support this, but then the other argument, as I said, that it would discourage the commercial and industrial consumers to set up rooftop when the production is more than 10 kilowatt. Now, let us look at two judicial pronouncements. One is on metering. Messrs. Aditya Industries versus Himachal Pradesh Electricity Regulatory Commission, which is a judgment of tribunal in the year 2014, where appellant objected to the difference of meter reading, one which was installed at the residence at the premise of which was at the premise of the appellant, not the residence, premise in the industrial location, and the other one which was installed at grid substation. And because of this differing price, the appellant asked for revisiting of the bill. Now, as per the regulation, it has been suggested that consumer meter has to be installed at consumer's premise or outside consumer premise. Regulation categorically says that installation of meter at grid substation was not correct, was not allowed, and therefore, when licensee has installed it and then taking a bill, charging a bill on the basis of reading which is showing in the meter installed at the grid substation, the appellate tribunal said that this is not as per regulation, because regulation says that you have to install meter at the residence of the consumer. In this case, or at the premise of the consumer, that would be the right expression, at the premise of the consumer. In this case, generally what has happened, I mean, the licensee brought this argument that it is been done for fair reading of the meter, and there was a sort of display meter, they installed at the premise of the consumer. The tribunal did not buy this argument. Tribunal said that regulation is very clear that it has to be at the premise, and therefore, it was wrong on the part of the licensee to install it at grid substation. This is another case which simply highlights the concurrent jurisdiction of Consumer Forum and Electricity Act, and because electricity consumer is also a consumer under Consumer Protection Act. Now, 1986 I have written here because this case deals with 1986 Act, though we know very well that now in 2019 we have a modified version of Consumer Protection Act in existence. This case is prominent because it categorically says that the reading of section 173 makes it very clear, and that is what we have also studied in the last session, that the rights of consumer remains unaffected under any other law, and that is what section 173 also says, that Electricity Act does not take away the jurisdiction conferred on the other forum, particularly the Consumer Forum. Electricity Act is in supplement of that, it is supplementing the redressal forum provided to the consumer. So, if the cause of action relates with the law laid down under the Consumer Protection Act, the consumer has a choice to seek redressal from the Consumer Forum. So, if it is about deficiency of service, then consumer can very well decide to go to the Consumer Forum or go to the redressal forum which is there under the Electricity Act. But then if the issue pertains to something which relates only to Electricity Act, for example, if it is about unauthorized use of electricity, then in such a situation Electricity Act alone will have prevalence there, alone will have operation there. The court says that if there is an inconsistency between Electricity Act and Consumer Protection Act, it is the Consumer Protection Act which shall prevail. So, you can very well look at this, you can very well make an observation that how the court in this case comes out with a legal interpretation favoring the interest of the consumer. It categorically gives a very purposeful understanding, purposeful interpretation to section 173 of the Act. So, this is on the rights of consumer. Thank you very much. These are the references to go through.